Our next speaker is Professor Alexander Vylegzhanin from Russia. He will speak on Russia's perspective on international law of cyberspace. Professor, the podium is yours. Please.
Thank you very much, distinguished Mr. Chairman, Excellency, dear colleagues. Many thanks for this invitation to MGIMO-University to be here with you. I'd like to emphasize that, of course, the ideas of other speakers today about conservation of or protection of diversity of languages, diversity of legal systems, diversity of cultures. Of course, this is very important. And I think that it is the function of international law to harmonize these different national legal regulations, even in such a specific area of international law as cyberspace. In my presentation, I just wanted to draw your attention that according to Russian teachings devoted to this area of international law, it is important to ascertain the meanings of the relevant key terms such as International Law of Cyberspace, International Law of Mass Information, the Law of Information and Communication Technologies. Another question is whether the term information space is equated with the state territory. As you could see from this slide, there are quite a lot of relevant law sources in the Russian Federation, beginning from National Security Strategy of 2021 and Basics of State Policy in the field of international information security, and ending with the decree of 2022 on additional measures to ensure information security. The last legal act obliges, in particular, companies, both foreign and domestic, to appoint deputy directors of the company specifically in charge for formation, I would say, security of this or that company. The legislation, next slide, the legislation of the Russian Federation is called sometimes in legal teachings as the centralized model of the regulation of the information and communication technologies. And the relevant Western countries are called as decentralized model. Of course, this is, of course, a purely theoretical assessment, but the idea is that the Russian documents favor strengthening specific universal international legal regulation of information space, while the Western documents usually favor evolutionary interpretation of the existing conventions, thus applying their rules to cyberspace. Of course, there are exceptions on both sides. Next slide. Like many other countries, Russia participated in developing, for instance, 2015 UNGE report. And this document provides in particular that states have jurisdiction over the ICT infrastructure which is located on its territory. And also states are to observe principles of international law, including, for instance, non-intervention in the domestic affairs of other states, as provided, by the way, by the UN Charter, Article 2, Paragraph 7. And of course, the indication that an ICT activity or that it originates from the territory of the ICT infrastructure of a state may be insufficient in itself to attribute the activity to that state. And of course, these provisions are discussed. Next slide. There are, yes, next slide. Next slide. There are also a number of unresolved issues, of course, as shown in this slide, the previous one. For instance, there are also moves regarding the further how to improve this area of international law, and this UN group on of governmental experts and developments is a very good positive example. Several states, China, Russia, Tajikistan, and Uzbekistan, proposed to adopt the International Code for Conduct of Information Security. And the core pillars of this document might be such as, for instance, again, protection of the principles of non-interference, according to the UN Charter, Article 2. And that is really very, very important, taking into account the technical possibilities of cyber technologies today. So the core ideas of the documents, legal documents, which are presented to the Russian legislation and legal initiatives are, first, the Americanization of the Internet. We understand that, of course, Internet was born in the United States, but today, more than 65% of users do not live in the United States and in other Western countries. So rules of international law are to be acceptable to the majority of states representing the majority of cyber users. The second, of course, idea is that according to Russian legal documents, the absence of universal international instruments on information security leads to further risk. Next slide. And my last slide shows that there is really a positive trend regarding international agreements already available, which reflect the interests of the majority of cyberspace users. Such among these relevant legal documents, for instance, the joint statements of the presidents of People's Republic of China and Russian Federation on the cooperation in information space development. Also, East Asia Summit Leader Statement on deepening cooperation in the security information and communications technology and of the digital economy, 2018. And joint communique of the meeting of the foreign ministers of the People's Republic of China, the Russian Federation, and the Republic of India. Many thanks.
Okay, thank you very much for your very interesting, excellent presentation on the Russia perspective, which also gave us a lot of food for thought. Thank you again.